A jury in Alaska convicted Zerius Hildebrand of second-degree murder and evidence tampering, but acquitted him of first-degree murder, finding the prosecution failed to prove premeditation beyond a reasonable doubt. The split verdict, delivered after what the judge called a long and difficult trial, means Hildebrand now faces a sentencing range with judicial discretion rather than a mandatory minimum of 30 years to life when he appears before the court on October 23rd.
That's right. In the matter of the state of Alaska versus Zerius Hildebrand, we, the jury, find the defendant Zerius Hildebrand not guilty of murder in the first degree as charged in count 1. We, the jury, find the defendant Zerius Hildebrand guilty of a lesser included offense of murder in the second degree as charged in count 1. We, the jury, find the defendant Zerius Hildebrand guilty of murder in the second degree as charged in count 2. We, the jury, find the defendant Zerius Hildebrand guilty of tampering with physical evidence as charged in count 3. We, the jury, find the defendant Zerius Hildebrand guilty of tampering with physical evidence as charged in count 4. Thank you.
The foreperson stood. The courtroom went silent. 4 counts, 4 verdicts. Not guilty of murder in the first degree. Guilty of murder in the second degree on count 1. Guilty of murder in the second degree on count 2. Guilty of tampering with physical evidence on counts 3 and 4. The judge thanked the jury. Sentencing was scheduled for October 23rd.
Thank you. Please be seated. As the parties understand, sentencing is put out sometime for a pre-sentence report. I have 2 potential dates, October 20th at 2 p.m. or October 23rd at 10 a.m. October 20th at 2 p.m. or October 23rd at 10 a.m. And those dates, it doesn't matter that much at this point what date we pick. If it doesn't work for the parties when we get closer, just contact Chambers and we can make sure that it's a date.
Everyone in that room understood that a man's life had just been permanently divided into before and after. But one word in those verdicts carries more legal weight than anything else the foreperson read. That word is lesser. By the end of this video, you will understand exactly what separates first-degree murder from second-degree murder, and why that distinction can mean the difference between life without parole and a sentence with a release date. In the matter of State of Alaska versus Zerius Hildebrand, a jury returned its verdict in a case tried in Alaska State Court. The jury found Hildebrand not guilty of murder in the first degree as charged in count 1, guilty of murder in the second degree as a lesser included offense on count 1, guilty of murder in the second degree as charged in count 2, guilty of tampering with physical evidence as charged in count 3, and guilty of tampering with physical evidence as charged in count 4. The judge presiding over the proceeding noted it had been a long and difficult trial.
No, Judge.
All right, thank you. I want to thank all of you for your service. This has been a long trial, a difficult trial in many ways. As I think I've noted before, you all were actively participating. I would keep an eye on you to make sure that everyone's still engaged. And I know that this is a long process, a difficult process, and you all took it very seriously and were active participants, and I appreciate that. I want to thank you on behalf of the court system and the state for your service. You are all excused at this point. Often the attorneys like an opportunity to chat with you if you're willing to stick around. You do not need to stick around. You're not obligated to do that at all. But if you want to, they may come down and chat with you if you're willing to stick around. I will come down and thank you again and then ask for any feedback that you have for how we can make things work smoother for you. But again, you don't have to stick around.
Sentencing was set for October 23rd. The presiding judge indicated the day would be blocked in full given the anticipated length of victim impact and sentencing statements.
If it doesn't work for the parties when we get closer, just contact Chambers and we can make sure that it's a date that works for everybody. Is there a preference between those 2 dates at this point?
Yes, Judge.
And what is that preference?
I think that we will probably need some time for this hearing, for the sentencing. So I would prefer we block off a significant portion time of October 23rd
Let me take a look if I have anything at this point. I don't think I have a date certain trial at that point, but let me.
The 23rd is a Friday. Yes.
Right. So if we start at 10, does that work? I can block off, what, 4-hour chunk? 2 hours?
I don't know that 4 will be sufficient, Judge. I imagine.
Zerius Hildebrand was a person before he was a defendant. Whatever his ordinary life looked like, his work, his relationships, the mundane texture of daily existence, it was interrupted by charges serious enough that a jury deliberated through what the judge described as a long and difficult trial. The practical weight of facing 2 counts of murder and 2 counts of evidence tampering in Alaska is not abstract. It means pretrial detention or restrictive release conditions. It means legal fees that in serious felony cases routinely exceed $100,000 before a verdict is read. It means that every person who knew Zerius Hildebrand had to decide privately what they believed and live with that decision while the system took its time reaching its own. The prosecution's theory in this case rested on a framework the jury ultimately accepted in part and rejected in part. The state charged first-degree murder on count 1, the most serious homicide classification available under Alaska law, requiring the jury to find that Hildebrand caused the death intentionally with premeditation and deliberation. That is the highest mental state the law recognizes in a killing. The state also charged murder in the second degree on count 2 directly, suggesting the prosecution believed the evidence on that count supported intentional or knowing conduct without the additional premeditation element, and the state charged tampering with physical evidence on 2 separate counts, meaning the prosecution argued that after whatever happened, Hildebrand took deliberate steps to conceal, destroy, or alter evidence of the crime. The prosecution's case, taken at full strength, told the jury this: a death occurred, Hildebrand caused it, and then he tried to make sure you would never find out. The evidence tampering counts were not afterthoughts. They were the prosecution's answer to any defense argument that the physical evidence was ambiguous or incomplete. If the defendant destroyed evidence, the prosecution argued that consciousness of guilt is itself evidence of intent. Jurors are permitted to draw that inference, and the jury found the tampering charges proven beyond a reasonable doubt on both counts. The state's premeditation argument on count 1, the argument the jury rejected, required proof that Hildebrand formed the intent to kill before he acted, that he had time to reflect on that intent, and that he carried it out deliberately rather than impulsively. That is a high bar. And here is what most people watching a verdict like this miss entirely. The jury's not guilty finding on first-degree murder is not an acquittal on the facts. It is a precision instrument.
Thank you. Does either party wish to have the jury polled?
No. No, Judge.
All right, thank you.
The jury was not saying the killing didn't happen. They were saying the state did not prove the specific mental state of premeditation beyond a reasonable doubt. That distinction passed without comment in the courtroom. It will define everything that happens at sentencing. Alaska Statute Section 11.41, 100 defines murder in the first degree, requiring intentional causation of death. Alaska Statute Section 11.41, 110 defines murder in the second degree, which can be satisfied by intentional conduct without the additional premeditation element, or by conduct showing extreme indifference to the value of human life. The legal distance between those two statutes is not large in ordinary language. Both involve intentional killing. But in sentencing terms, the gap is significant. Under Alaska law, first-degree murder carries a mandatory minimum of 30 years and a maximum of 99 years or life. Second-degree murder carries a presumptive range that, for most defendants, sits considerably lower. The question the cross-examination in this case was designed to answer was whether anything in the state's evidence established the deliberate, reflective mental process that premeditation requires, or whether the evidence was equally consistent with an intentional act that lacked the planning element the first-degree charge demanded. The cross-examination of the state's key witnesses in a premeditation case follows a specific logic. The defense does not need to prove innocence. It needs to create reasonable doubt about one element, the deliberate formation of intent before the act. Every question is a tool aimed at that single target. Did the witness observe any evidence of planning, any communications in advance, any preparation that could only be explained by a decision made before the moment of the killing itself? If the answers are no, or if they are uncertain, or if the witness concedes the evidence is consistent with an impulsive act, the premeditation element begins to fracture. The defense asks, "You found no written plan?" Correct. No written plan. You found no communications indicating advance intent. Correct. The witness qualifies. The defense presses. The qualification becomes an evasion. The evasion damages credibility more than a concession would have. You cannot point to a single piece of evidence that shows a decision was made before the moment of the act. Can you? What the witness says next either holds the prosecution's theory together or breaks it. If the answer is a genuine concession, if the witness acknowledges the evidence of premeditation is circumstantial and inferential rather than direct, the defense has accomplished something the jury will carry into deliberations. Not an acquittal, a wedge, a reason to look at count 1 differently than count 2, a reason to find the higher mental state unproven while still finding intentional killing established. The jury found exactly that wedge. Not guilty on first degree, guilty on second degree. Here is what that means in the real world. The difference between a first degree and second degree murder conviction in Alaska is not merely symbolic. It is the difference between a mandatory minimum of 30 years and a sentencing range that gives the judge discretion. Discretion means the defense can argue at the October 23rd sentencing hearing. It means mitigating factors can be presented. It means the outcome of that hearing is not predetermined. That is what the defense's cross-examination bought, not freedom, but the possibility of a future conversation with a judge who has room to move. What should have happened differently here requires examining the prosecution's decision to charge first-degree murder when the evidence of premeditation was apparently not strong enough to survive a jury's scrutiny. Under Alaska Criminal Rule 8, the state is required to bring charges that are supported by probable cause. But probable cause is a low threshold, far below proof beyond a reasonable doubt. The more demanding standard is the one prosecutors should apply before charging whether the evidence, viewed honestly, is sufficient to prove every element of the charged offense beyond a reasonable doubt to a rational jury. That standard is sometimes called prosecutorial sufficiency review, and it exists precisely to prevent overcharging. If the state's evidence of premeditation was primarily circumstantial and inferential, a thorough pre-filing review should have surfaced the risk that the first-degree charge would not hold. What a properly prepared prosecution would have done differently is either secured additional evidence of planning before filing, communications, witness statements, surveillance, or charged second-degree murder directly and built a case it could prove completely rather than one the jury partially rejected. The cost of that overcharge was not borne by the prosecution. It was borne by Zerius Hildebrand, who spent, however, many months this trial lasted carrying a first-degree murder charge, the maximum legal accusation the state can bring against a human being, based on evidence a jury ultimately found insufficient. No mechanism in Alaska law requires the prosecution to account for the decision to overcharge when the overcharge fails. The state loses the count. The defendant absorbs the cost of having faced it. The second annotation here connects to what the defense's cross-examination strategy was actually trying to accomplish at the element level. Alaska Statute Section 11.41, 100 requires proof of intentional causation of death, that is the shared element between first and second degree. The differentiating element is the premeditation requirement. The state must prove the defendant formed the intent, had an opportunity to reflect on it, and acted deliberately rather than impulsively. That element is not defined in the statute with mathematical precision, which is precisely why it is contested in almost every first-degree murder case. The defense cross-examination was designed to attack the evidence supporting that reflection period, the gap, however brief, between the formation of intent and the act. Most people believe that premeditation requires days or weeks of planning. That is not what Alaska law requires. Courts have found that a matter of seconds can constitute premeditation if the evidence shows the defendant had time to reflect. But if the evidence shows only that violence occurred, without evidence of the cognitive step of reflection, the element fails. The cross-examination planted enough doubt about that reflection element that 12 jurors unanimously declined to find it proven. That is not a small thing. That is the constitutional standard of reasonable doubt working exactly as the Sixth Amendment requires. The prosecution's closing argument asked the jury to look at the totality of the evidence, not just the act itself, but the tampering that followed. If Hildebrand destroyed or altered evidence after the fact, the prosecution argued, the only rational explanation was that he knew what he had done and knew it was wrong, which is itself evidence of the deliberate mental state first-degree murder requires. The tampering counts in this reading were not just separate charges, they were the prosecution's strongest circumstantial evidence of premeditation, a person who plans a killing plans for its aftermath. The evidence tampering, the prosecution argued, was part of the same deliberate plan. The defense's counter was equally precise. Consciousness of guilt, the defense argued, does not establish the timing of intent. A person can act impulsively and then, in the aftermath, make desperate decisions to conceal what happened. Concealment after the fact does not prove planning before the fact. Those are two different mental states at two different moments in time, and the prosecution was asking the jury to collapse them into one. The jury, the defense argued, should evaluate the evidence of what happened before the act separately from what happened after. The after is proven. The before is not. The question the judge had to resolve, the one neither attorney's argument fully answered, was whether the jury instructions they had agreed upon gave the jury sufficient guidance to draw that precise line between before and after in their deliberations. Not guilty of murder in the first degree, guilty of murder in the second degree. The jury drew the line, and the ruling that followed, accepting that verdict without polling the jury, was constitutionally and procedurally correct under the bedrock principle of jury finality. Once a jury returns a verdict in open court and the parties decline to request polling, the verdict is final as to the findings of fact.
As we get closer to it, just contact Chambers and we'll work on picking a new date. All right. Anything else today? Do either parties intend to go chat with the jurors?
I always like to hear from them, if anybody's stuck around.
I guess so, yeah.
Ms. Brewster, I couldn't hear you.
Yes, Judge.
Okay. All right. I'm going to run down there and thank them again, and then I'll get out of your way and you can...
The judge's role at that moment is not to evaluate whether the jury reached the right conclusion. It is to receive the verdict, confirm its form, and schedule what comes next. That constraint on judicial review of jury factual findings is not a loophole. It is the Sixth Amendment's guarantee that the right to trial by jury means something, that 12 citizens, not one judge, determine the facts. This is the same constitutional bedrock that the Supreme Court articulated in Apprendi v. Jersey 530 U.S. 466 2000, which held that any fact that increases a criminal penalty beyond the statutory maximum must be submitted to a jury and proven beyond a reasonable doubt. The Hildebrand jury's decision to find premeditation unproven was an exercise of exactly that constitutional function, a factual finding within the exclusive province of the jury that no court can reverse simply, because the judge might have weighed the evidence differently. Verdicts are not always what they appear to be. A not guilty finding on the highest count is not always a victory, and a guilty finding on a lesser charge is not always a defeat. It depends entirely on what the lesser charge carries at sentencing. Every American who has ever been accused of something they partially did or partially did not do lives in the space between those verdicts. The justice system's ability to distinguish between degrees of culpability is one of its most important functions, and when juries exercise that function carefully, as this jury appears to have done, it is worth understanding exactly what they decided and why. Zerius Hildebrand will be sentenced on October 23rd. What happens in that courtroom will be determined by evidence of who he was before and after the day that divided his life in two. Next, this channel examines what happens when the evidence tampering charge is the weakest link in the prosecution's entire case, and whether a conviction that rests partly on destroyed evidence creates a constitutional problem at sentencing that most defendants never know they have the right to raise. Was the jury's decision to convict on second-degree murder while acquitting on precise and constitutionally correct exercise of their fact-finding function demonstrably as in charge an element by element or chanon? There's a split word like slonism is used to intend offense as a component like leftism that splits the division and acquittal rather than applying the law's distinct standard rather with evidence after them applying the law's installation of the Lord of and if the latter is true, what safeguard, if any, exists to ensure that a lesser included verdict actually reflects a genuine finding on every required element rather than a jury's negotiated piece?